Assalamualaikum. My name is Karuddin Mirukib. I'm from BTMI Station 2. I'm from Group 7. We will present our topic for assignment is Aversion to Trade and Case Law. We have 7 members in our group. First is me, Kai. We have Rakib. We have Dinul Hakim. We have Adam. We have Anis Adlina, Anis Zati, and also Anis Yasmin. So we go to our topic. Check it out.
Assalamualaikum. My name is Muhammad Adam Shah bin Awang. Today, I would like to present an introduction to the invitation to trade and case law. That necessity has made an invitation to trade a fundamental concept in contract law, sometimes misconstrued but essential to capturing the parameters of legal liability. It means an introduction, a warning that a person is willing to talk or engage in a contract, but not yet contract. This distinction becomes particularly important in distinguishing it from an offer, acceptance of which result in a contract legal binding. Next, let's picture real-life scenarios. For instance, advertisement, window, display and sales, auction. However, when a shop has fittings of commodities with price label at the window, what it is doing is provoking beggings. This distinction, though very thin and important, has been perfectly illustrated in common law cases such as Carly v. Kobalik smoke ball, where the difference between an offer and invitation to trade was considered. This is a basic fact that every person with any dealing in business or contract needs to understand. They go a long way in clearing intention of parties and preventing hasty, unproduced quarrel, leading to better cooperative agreement. That's all. Thank you.
Hi, Assalamualaikum. My name is Nur Anis Adlina Benten Pauzan, and today I'm going to presenting about case law Hyde v. Range Active 14. So, in the case of Hyde v. Range Active 14, the dispute arose when Mr. Range offered to sell his farm to Mr. Hyde for £1,000. Initially, Mr. Hyde expressed interest but responded with a counter offer of £915. So, Mr. Range rejected the counter offer. Subsequently, Mr. Hyde sought to accept the original offer of £1,000, but Mr. Range refused to honor it. The central ledger issue in this case was whether a counter offer terminates the original offer, thus preventing the offeree from later accepting the original terms. So, the court in its decision ruled in favor of Mr. Range. It held that Hyde's counter offer of £915 effectively rejected the original offer of £1,000. As a result, the original offer was no longer available for acceptance. The court reasoned that a counter offer acts as a rejection of the original offer, and once a counter offer is met, the original offer is terminated and cannot be revived. So, this case holds significant relevance in the context of contract law, particularly in relation to the principles of offer and acceptance. It underscores the fundamental concept that a counter offer terminates the original offer. Hyde v. Range is a critical example of how counter offers alter the status of negotiations, and it serves as a reminder that an agreement is only formed when there is a clear acceptance of an offer without any conflicting terms. So, for the conclusion in this case, Hyde v. Range remains a pivotal case in contract law. It highlights the importance of clarity in negotiations and the effect of counter offers on contract formations. Once a counter offer is met, the original offer ceases to exist and the contract cannot be formed unless the terms are unequivocally accepted. So that's all from me. Thank you, everyone.
Assalamualaikum to Dr. Ain. My name is Nur Anis Izzati binti Kamul Zaman and I am from Group 7. So today I would like to explain further about the case that happened between Harvey and Facey in 1893. So the case started when Harvey sent a telegram to Facey asking if he would like to sell the Bumper Hall brand, and if so, what was the lowest price will be. Facey then responded to his telegram by saying that the lowest Bumper Hall pen price is £900. Harvey later responded again and said that he would like to buy the property with the lowest price. Facey countered that his response was not an offer but only an invitation to trade. So what was the legal issue in this case? The key legal issues in this case was whether Facey telegram, which stated the lowest price for the property, qualified as an offer that could be accepted, and when Harvey accepted, created a legally binding agreement. The question in this case was whether Facey response was an offer or just an invitation to trade. So what was the decision and reasoning of the court? The court ruled in favor of Facey, holding that no contract had been formed. It reasoned that Facey telegram, which simply stated the lowest price for the bumper hold brand, was not an offer but an invitation to trade. The court emphasized that a statement of price does not by itself constitute an offer capable of acceptance. Therefore, there was no binding contract was created when Harvey responded with his offer to purchase the property. There is two relevance to the topic. Firstly, distinction between offer and invitation to trade. This case highlights the important legal distinction between an offer and an invitation to trade, which is a fundamental concept in contract law. Secondly, contract formation and communication. This case underscores the importance of clear communication in contract formation. It illustrates how important or incomplete statement would be or do not automatically result in a contract, and emphasize the need for precise terms and clear intent to form an agreement. This principle is relevant to modern business and consumer transaction.
Alright, it's back to me again. I will talk about my case law. By the way, my name is Kai. My case law is about Gibson versus Manchester City, 1979. So what happened at the time that the council informed Mr. Gibson that it will willing to sell the house, providing the potential sale detail, but the language lack of defined unqualified commitment. So at that time, the court analyzed whether the council letter stating the willing dispose of the house constituted a firm offer or invitation to trade. It concluded the letter was invitation to trade, it not a legally binding offer if the letter was invitation to trade. So the court decision at that time said the House of Lords ruled that council letter stating may willing to dispose of the property was in person not the considered a valid offer because it's qualified it was classified to the invitation to trade, not to sell. So what the relevance of topic? The relevance of topic is the council letter saying may will prepare to sell was not a firm offer but is an invitation to trade. This means the council was open to negotiate and Mr. Gibson's application was seen offer council call will be accept or reject.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Hakim bin Ismail Rizal. Number metric B062310331. Today I want to talk about case law about Pharmaceutical Society vs. Booth 1953. For the first one is case fact. For the case fact, Pharmaceutical Society vs. Booth 1953, the case states that a display of goods in a shop window or on the shelf of a self-service shop is generally regarded as an invitation to trade rather than as an offer to sell. The case happened as certain products that were to be sold only under the supervision of a registered pharmacist were displayed on the shelf in a self-service shop. The second one is legal issue. The first problem was whether placement of product on the shelf of a self-service store can be qualified as an offer or an invitation to trade. The Pharmaceutical Society said the display of the good was an offer and the agreement to supply form on the act of the customer taking the product which could possibly contravene the Medicine Act of 1858, under which required drugs should only be sold only with the supervision of a pharmacist. The last one is the decision and reasoning of the court. The Court of Appeal held that the defendant was not in a breach of the Act, as the contract was completed on payment under the supervision of the pharmacist, The display of the goods on the shelf was not an offer which was accepted when the customer selected the item. Rather, the proper construction was the customer made an offer to the cashier upon arriving at the till, which was accepted when payment was taken. This analysis was supported by the fact that the customer would have been free to return any of the item to the shelf before payment had been made. That's all from me. Thank you.
Warahmatullahi wabarakatuh. My name is Auni Yasmin binti Muhammad Nazir. I'm from BTMI section 2-1. So today I will be presenting about the case of Fisher v. Bell in 1961. It's about a landmark case that in contract law that clarify about the distinction between an offer for sale and invitation to trade. So this case is a bit critical to understanding how legal principle of contract law that intersect with statutory interpretation. So we discuss about the case facts. So in 1961, a shopkeeper displayed flick knife in his shop window with the price tag. So he was charged in section 1.1 of the Restriction of Offensive Weapons Act 1959. So next is about the legal issue. It was whether the display of the knife in the shop window amount to an offer for sale, so which will make the defendant guilty. And the second one is an invitation to trade, which will mean no breach of the law. So the court had to decide whether the statutory language aligned with the general principle of the contract law. So next is about the court decision. The court held that the display was not invitation to trade, not an offer for sale. And in a contract law, a display in a shop window is an invitation to potential customer to make an offer, not a definitive offer from the shopkeeper. So as the Lord Parker CJ said, that a statute must be looked at in light of the general law of the country. Therefore, the defendant was found out not guilty because the statutory requirement for an offer was not met. So for the legal principle highlight, a display of goods in the shop windows invite customer to make an offer to purchase. So it is not legally binding for offer to sell. And for the law contract principle, which is guide statutory interpretation unless explicitly contradicted by the statute. And thus, for the relevant contract law, official verbal clarified that shop displayed are not an offer, but invitation to negotiate. And this protects seller from being legally bound by a display alone. And for the impact of the future case, it might affect how court interpret advertisement and display in retail. So for the conclusion about this case, Fisher v. Bell in 1961 highlight the content that critical need between the legal meaning of the statutory language and the case key principle of the contract law, and particularly the distinction between an offer to invitation for the trade, and continue to guide court in interpreting display, advertisement, and offer in legal context. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Rakib bin Shahrin. Today I want to present about analysis and reflection. The first is a distinction between offer and invitation to trade. An offer is a binding proposal, while an invitation to trade invites negotiation. The first case is about Hyde vs. French 1840. establish the effect of counter offers. Second one is Fisher versus Bell 1961. Displaying goods is an invitation to trade, not an offer. Next one is Pharmaceutical Society versus Boots 1953. That's clarified that items in self-service shop are invitation to trade. Next is impact on legal principles. Harvey versus Facey 1893. This case is about stress precision in contract terms. The next one is Gibson versus Manchester City Council 1979. This case highlights the needs for clear communication in contracts. In modern legal influence, this case shaped consumer right, retail practice, and contract drafting, emphasizing the importance of clarity and intent in legal agreement.